Nsem-Pii TV. Your mom and boss for you. I think say Obia Nsem-Pii TV.
Entrepreneurship maybe.
Nsem-Pii. Yeah, you ask good questions. I hope sir you continue with your good questions.
Be the first to know Nsem-Pii TV.
For quickly, no, you ever in Supreme Court. Chief Justice get to talk on. On 4 judges or more sorry, kakra say or more coaching best now, or more or more final ruling about science. Bagbin file application, you know, and Supreme Court. The kind of one I will say, Supreme Court. A ruling on Mudi can de buy so no Bagbin as a mawaka yemonton kuneno or best court no a day tabono etoso na court no sa se san o mano e free sa se de etoso mi no afenyo marking application or the abeto menum yemonton gukura na Chief Justice na tredwe ma o de ruling ni nyina atudwa na in fact sa Bagbin ti ruling na Chief Justice de tudwa na menya sure se na ni beji. Because Chief Justice discipline ye papa yenti sama Chief Justice said to in the full judgment or deliver and the Supreme Court
can be seen from the very first page of the 1992 Constitution that the most fundamental and hallowed right of every Ghanaian that the 1992 Constitution gives and jealously guards is that when anyone, including the president and vice president, is embarking on an act, on any act that violates any provision of the Constitution, or if anyone is of the considered opinion that any law or rule enacted by any legislative body breaches the Constitution, that person can run to the Supreme Court for enforcement of the Constitution. That person does not even need to be directly affected by that act or law. This Supreme Court regularly exercises this original and exclusive jurisdiction for citizens of this country. Second, Article 130 provides, 131, subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction and in A, all matters relating to the enforcement or interpretation of this Constitution. All matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or persons by law or under this Constitution. Where an issue that relates to matter or question referred to in Clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination. And the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court. This means that if anyone finds that a meaning is being given to any provision of the 1992 Constitution that the person disputes, or that any act is being done by reason of a disputed meaning given to the Constitution, then Article 2 and Article 131A mandates that only the Supreme Court has jurisdiction to provide the people of Ghana with a correct interpretation of the provision in the Constitution. Third, it is the most basic tenet of our legal system that different courts operate in different jurisdictions, and every court is given its own jurisdiction. So the type of cases that can be settled in any court depends on the nature of the dispute. Thus, if someone is challenging that a member of Parliament has not lawfully won their seat, that challenge must be done at the High Court in the region that the constituency is in. However, if any two people challenge that the process of electing the same member of parliament did not conform with the constitutional provision, that dispute over the correct interpretation or meaning of the constitutional provision must be brought to the Supreme Court for interpretation. Indeed, if the dispute over correct interpretation or meaning of the relevant provision occurs while the parties are before the High Court must, by direction of Article 132, stop hearing the case and refer the dispute over the correct interpretation of the Constitution to the Supreme Court. There are many cases on this manner of resolving disputes requiring constitutional interpretation, including ex parte Senator Rawlings, citation provided. In every given month and year, the Supreme Court regularly deals with cases seeking interpretation and enforcement of provisions of the 1992 Constitution. And every law report issued every month is filled with such cases. It is therefore misinformation and misapprehension of law for the applicant to present that the Supreme Court has no jurisdiction to provide the correct interpretation of Article 97(1)(g) because Article 99 gives jurisdiction over determination of membership of Parliament to the High Court. Article 99 reads, "The High Court shall have jurisdiction to hear and determine whether a person has been validly elected as a member of Parliament, or the seat of a member has become vacant, or a person has been validly elected as a Speaker of Parliament, or having been so elected has vacated the office of Speaker. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal." From the above, it can be seen that if anyone raised the question whether a person has been validly elected as a member of Parliament, or a seat of a member of Parliament has become vacant as a matter of fact, that person is required to go to the High Court for the High Court to resolve any issues around that question. In the instant case, the records brought to the Supreme Court submitted that the question was raised on the floor of Parliament, that by filing nominations to contest as independent members of the 9th Parliament, members of the 8th Parliament should be deemed, by reason of the meaning of Article 97(1)(g), to have vacated their seats in the 8th Parliament. Thus, the vacation of seats is not a matter of fact from death or resignation or notice by the parties themselves to Parliament. It is to be taken from an interpretation and enforcement of Article 97(1)(g). It has been argued by counsel for the Speaker that what the Speaker presented to Parliament on 17th October did not constitute a ruling that was executable or amenable to the controversy raised in this suit. On the contrary, MPs cannot be allowed by law and my good self to continue to pretend to be representing people that they do not believe in and have no loyalty for in this House any longer. The House is accordingly informed, unquote. These are words that affect the rights of these MPs to remain in Parliament and the rights of their constituents to their representation. Thus, if a controversy is raised to the propriety of the interpretation of Article 97(1)(g) that led to this conclusion, then this court is rightly sized with jurisdiction to provide a hearing to the plaintiff. According to the plaintiff, the Speaker's interpretation of Article 97(1)(g) was wrong because he, the plaintiff, also interpreted Article 97(1)(g) as affecting members of Parliament who wanted to change party affiliation. He also interpreted it as affecting the status of parliamentarians in the next Parliament and not while sitting in the 8th Parliament. These and others are the disputed interpretations that the plaintiff presented to the Supreme Court to give the nation the correct meaning of. For the sake of the record, we set out Article 97.1. A member of Parliament shall vacate his seat in Parliament upon the dissolution of Parliament, or if he is elected as Speaker of Parliament, or if he is absent without permission in writing of the Speaker and he is unable to offer a reasonable explanation to the Parliamentary Committee on Privileges from 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet. Or D, if he's expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, or E, if any circumstances arise such that if he were not a member of Parliament would cause him to be disqualified or ineligible for election under Article 94 of this Constitution. Or F, if he resigns from office as a member of Parliament by writing under his hand, addressed to the Speaker. Or G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2, notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original or political party forms part shall not affect the status of any member of Parliament. Now, clearly, with the disputed interpretations alleged in the plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself. We have considered the objection to the procedure used to serve the Speaker because of the administrative circular of the Chief Justice in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the Supreme Court to serve the processes of the Speaker of Parliament were actually in conformity with law and the circulars issued by the Chief Justices in 2021 and 2024. Exercise of discretion. The Speaker of Parliament is urging that the Supreme Court breach the rules of natural justice and rules prescribing the manner for exercising discretion in the orders made on 18th October 2024 in hearing the application ex parte and granting orders to stay execution of the Speaker's ruling pending the resolution of the suit. It is a very basic and primary principle of law that an order of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if an order of stay of execution is not granted. In the ruling of the Supreme Court on 18th October 2024, the Supreme Court was very clear that its orders were being made because of the exceptional circumstances that would flow from the effect of the ruling of the Speaker of Parliament declaring the 4 seats vacant and a determination not to allow the MPs to remain in Parliament. What are some of the effects that weighed on our minds as exceptional circumstances that were alluded to in the ruling? The 4 constituencies of Nsem-Pii Central, Fomena, Aguna West, and Suhum in the Western region, Ashanti region, Central region, and Eastern regions of Parliament are made up of hundreds of thousands of Ghanaians who had queued to elect these members of Parliament to represent their interests in Parliament as their voices. By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97(1)(g) by the Speaker was actually enforcing this interpretation of Article 97(1)(g) against those hundreds of thousands of Ghanaians, and not just the 4 people that sit in Parliament. He was also doing so at a time that from the official records of Parliament presented to the Supreme Court, the Speaker knew that a contrary interpretation was being placed on the same constitutional provision and that the Supreme Court's jurisdiction had been invoked to provide the correct interpretation. By reason of law, there could be no by-election to replace these elected representatives between 17th October 2024 and 7th January 2025. So, 7th January 2025. 2025. So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7th January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance arising from the outcome of the ruling weighed on the mind of the Supreme Court to grant an order directing a stay of execution of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the 4 members of Parliament is the current second Deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved. The consideration of these exceptional circumstances was clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of Parliament for 17th October 2024 was placed before the Supreme Court as an exhibit. The record showed that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday.